Assalamualaikum warahmatullahi wabarakatuh. Today I'm going to explain about gene and pattern. Okay, for the gene are basic physical or functional unit of heredity. Genes are made up of DNA. Some genes act as instruction for making molecules called proteins. However, many genes do not encode proteins. In humans, these are vary size of hundreds of DNA bases to over 2 million bases. As for the human gene, everyone has two copies of each gene, one inherited from each parent. Most genes are same for all, but few genes vary slightly from person to person. For the animal gene inherited traits and disorder are inherited by animal's genetic code. This genetic code is found in animal DNA. This is a long molecule found in various cells in the body. The DNA contains thousands of genes. A gene is a specific consequence of DNA that result in expression of genetic trait. For example, there are genes that determine eye color, the coat's color, and body characteristic. Okay, next for the patent. A patent is a government-issued award that grant the owner of the invention exclusive right to prevent others from utilizing it without their permission. In exchange for this benefit, the proprietor must give a total exposure of the invention to the society, allowing any person versed in the art to carry out or work on the innovation. As a result, the patent system might be viewed as a social contract between the government and the inventor. Its symbiotic approach helps society since it promotes investment, science research, and industrial growth, all of which contribute to the wealth accumulation for economic and social prosperity. The Patents Act 1983 and the Patent Regulation 1986 govern patent protection in Malaysia. These statutes, which took effect on October 1, 1986, established Malaysia's independent patent registration system. Before October 1, 1986, obtaining patent protection in Malaysia required first obtaining a patent registration in the United Kingdom and then re-registering the same in Malaysia. The re-registering will give the registrant in Malaysia similar benefit and right as if the patent had been obtained in the United Kingdom.
Overview. Rapid development in biotechnology has led to many kinds of treatment and solution based on genome-based treatment and DNA testing related. This treatment is available by making use of specialty of each human gene, as humans can vary in their antibodies and DNA. Inventions has been made to make it possible to extract human genes from the human bodies and be manipulated in laboratory, resulting to production molecular medicine. It can be seen that human genes have created some value for the developer and researcher to benefit from their research and development in human genes and to be marketed in genetic testing industry. The issue is whether human genes can be patented. Generally, United States Supreme Court in 2013 has ruled that human genes cannot be patented on the basis that they are product of nature. It cannot be claimed as human inventions. The gene is natural product of humans. Justice Clarence Thomas has cited that by separating the human genes from the human bodies, it cannot be considered as an act of invention. So it has been said that human genes have not fulfilled the requirements to win a patent. However, the decision stated only applies to natural human DNA. It is permitted to patent human DNA after laboratory reconstruction. It is known as complementary DNAs or cDNAs. Legally effect, human genes is possible to be patented if the criteria is met. It is having to be regarded as invention and as discovery from human bodies by undergoing alteration of the gene to be counted as man-made by the court. The standards of patentability are applied around the globe as well as in the Europe, which is the issuance of patent is by European Patent Office (EPO). Moving to current position in Malaysia, Patent Act 1985 was drafted before the rapid development in biotechnology. So, it does not provide specific section about patent regarding human genes and no clear distinction between discovery of gene and its invention, unlike the patent of human genes regulation in the United States and worldwide. Section 31, subsection 1 mention whatever inventions which against morality and public order according to eyes of law could be refused and invalidated from the grant of patent. And the Article 27 of TRIPS Agreement also state the same. So the rapid development of biotechnology which lead to patenting to human genes might be tricky and controversial to be applied in Malaysia because it involves human bodies. So it can be said may open to the risk of commercial exploitation. Furthermore, Malaysia is majority Muslim country and the process resulted from the patent of human genes must undergo National Fatwa Committee. It is likely would not be allowed because of the contrary to the Islam belief, because patent human genes would be mean to the possibility of industry of human cloning and genetic engineering industry. Both of them are against the teaching of Islam. The conclusion is Malaysia does not have a proper law and regulation regarding patent human genes as there is still no significant development by its own laboratory in human genes research. Hence, the issue of patent of human genes does not widely discussed or focused by policymakers yet.
Moving on to the next subtopic, which is patenting of animal genes. So for the overview of this case is that animal patents as a whole have stayed out of the spotlight so far. Rather than animals, today's patent material in the sector of biotechnology concentrate on people and plants more. So there are two cases that I will explain for today, which is Harvard on Commerce patent and Leland Stanford patent. So for the Harvard on Commerce patent, it is a product of extraordinary human ingenuity, wherein every cell in the animal body was modified by changing genetic material that does not occur naturally in this form. The patent application was modified to remove composition of matter claims on transgenic animal. On this revised claim, the patent was eventually issued to Harvard College in 2003 for 70 years. The European Patent Office subsequently cancelled the patent in 2005 due to the failure to pay fees. Next, the problem was a genetic modification animal in the Leland Stanford patent, but this time was a test animal for X research. The patent was cancelled on formal ground in 2002 after the opposition procedure. The sheep named Tracy in the subject of a patent for protein production by a mammal. The patent was for the animal cell and the animal itself, whose genetic material included the genetic construct. The invention might be utilized to make blood coagulation components and proteins for food such as the host mammal natural or modified milk proteins or enzyme. It was granted in 1997. However, an appeal was rejected in 2002. So for the current position of Malaysia regarding patent animal, we can see that in the section 13 clause 1 clause B of the Patent Act 1986. So what this section talking about is that plant or animal varieties are essentially biological products for the production of plants or animals other than man-made living microorganism. Microbiological processes and the product of such microorganism process are listed as non-patentable invention. However, the word animal varieties as used in this section is uncertain. This is due to the legislation failure to evaluate the needs and consequences of the exclusion. The parliamentary discussion and the exclusionary provision text provide little comfort in the face of these concerns. This is because there is now a gap in Malaysian patent law regarding its applicability. Because Section 31, Clause 1, Clause B has not been applied in any patent application involving transgenic animal filed with the Patent Office, the MAIPO has not extensively studied the exclusion. More crucially, the exclusion has not been interpreted by Malaysian court.
For the conclusion, the patent law grants patent protection for different types of invention related to the genetic resources. At the same time, most patent systems provide a uniform treatment for all invention regardless of type of invention and field of technology. They apply the principle of non-discrimination to the industry technology in terms of patent availability. The term patent, which protect chemical components, machine, processes and other type of invention of great value due to their industrial applicability. Next, the human gene are not patentable subject matter under the Section 101 of the Patent Act because they are product of nature. If the molecule reverse transcribed from the messenger to abnormal intron sequence, so-called complementary DNA or cDNA, are patentable. Justice Thomas' ruling stated that a natural occurring DNA segment cannot be patented because it is a product of nature and it has been isolated, but the cDNA can be patented because naturally happened. On the other hand, for the animal patent, legal protection of invention regarding animal material is acceptable as long new and exclusive rights do not interfere with the traditional breeding process and the animal ownership. But last but not least, patent cannot protect all the invention. This is all from us. Thank you.